Well, welcome. Thank you for coming. It's wonderful to be here. It's a wonderful presentation so far. I'm really enjoying it. I don't know which was harder. The topic saying Paris, did it save the world, or Paris, its impact on environmental jurisprudence in Australia. Both have to look backwards, but they also have to look forwards. Mine involves a little bit more crystal ball gazing. I've got no slides of graphs and showing what is going to happen or videos of the impact on corals. All I can do is try and look at the bare bones of the Paris Agreement and then draw upon that to say what might be the effects. So there's a little bit of speculation, definitely not really judicial, but I hope you find something of use in what I'm going to do. Okay. So the first is we've had introduction to Paris, and we can see that it's a successful treaty. Some have said that it has come into force in record time, which is unusual. Normally there can be the enthusiasm of the signing, but then take a while to get the requisite number of countries to ratify it. But there was a rush in this case, which was a good thing, and it's come into force. A theme I'm going to come back to is that it's the first universal sort of climate change agreement that requires all parties to communicate ambitious emission reduction targets that reflect the common but differentiated responsibilities and the respective capabilities in light of the different national circumstances. So the way I'm going to structure our discussion is firstly just start and remind ourselves of what are these obligations and what is the effect under international law, because part of the environmental jurisprudence might be what might be the responsibilities of a nation state such as Australia under international law. The next topic I'm going to do is to look at, well, could those international obligations and commitments under the Paris Agreement be implemented domestically, and what might be the obligations there? The next one is I'm going to look a bit more creatively and try to say, is there something in the fabric and the text of the Paris Agreement that may influence the norms and values that underpin our law? And so I'll try and show you where there may be some effect there. The next one is to look at certain factual questions. Causation is obviously one, but there are other factual questions. Now, some of these you may think, when I show you, oh, this is reasonably obvious. But we have to remember it wasn't so long ago that they weren't universally accepted, and that means that their acceptance through the Paris Agreement may be influential in courts making certain factual findings. The next one is to start looking at what the private sector, what might be the impact of the Paris Agreement, not on governments and its activities, but more on the private sector. And I particularly just want to pick one aspect of that, and that is the impact on directors' liabilities. And the last is a quick point just to talk about the ripple effect that Paris has on litigation elsewhere, and then how it may impact in Australia. Right, let's start with the first. So, what are these obligations? Now, Justine has covered them, so forgive me if I cover a little bit of the same, but it's probably worthwhile me just to focus on a few of these because I want to then use those as the stepping stone for the later discussion. So the central objective that we saw up on the screen was to stabilise the greenhouse gas concentrations at a level that would prevent dangerous anthropogenic interference with the climate system. I want to come back to that. Notice the words anthropogenic interference with the climate system, and that's dangerous. It obviously builds upon the Framework Convention, that is the Paris Agreement. It builds upon that Framework Convention. So what are the core elements? Well, we've seen some of them. The first is that central aim, to strengthen the global response to the threat of climate change by holding the increase in the global average temperature to well below 2 degrees above pre-industrial levels, and pursuing efforts to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels. The mechanism is that the countries, this bottom-up approach that Justine was talking about, you have these nationally determined contributions. So all parties must contribute the emission reduction targets and pursue the domestic mitigation measures. Now, there's this concept of ambition, but we're talking about ratcheting up. You can think about, if you've got your ratchet, you're stepping up. So whatever the countries set as their NDCs, that sets the baseline for that country. They have to be more ambitious, i.e. reduce greenhouse gas emissions from their countries the next time they put something in. There will be a stock take and to see every 5 years as to how the countries are going. As Justine said, at the moment, the indicative NDCs before the Paris Agreement, when they added them up, would mean about 2.7, some say maybe up to 3.3, but it's certainly quite high, so further work needs to be done. Then there's the support mechanisms. I don't want to deal too much with those, about finance and technology and capacity building. Transparency, there is no mechanism for enforcement. No one's going to be sort of taken to the ICJ if they don't meet their national their NDCs, but there is still a transparency framework of disclosure and discussion in the compliance mechanism. And then there's the adaptation, and that's important as well under Article 2. And I'll come back to that concept about adaptation because it's indicative of a particular fact and agreement. So just looking now at these sort of the big ones, what are these obligations? And if we just take the Australian government, we've ratified it, and so we've party to it. What are the obligations? Well, the first is that we had to prepare and communicate a new and more ambitious NDC every 5 years, and we have to provide the information necessary for clarity, transparency and understanding of what is our target. I've set out there a number of the articles which back that up. So, is it enforceable? Well, what's the mechanism for compliance? Well, these obligations about NDCs are essentially administrative and communicative requirements. Australia will meet those with minimal additional effort, so there's not likelihood that Australia is not going to comply with those obligations. The next is the obligation to pursue domestic mitigation measures with the aim of achieving the objectives of Australia's NDCs. And so I've set out the obligation there. Now, Justine mentioned we have that sort of direct actions policy. That's been adopted with the aim of pursuing our domestic or our NDC. Some of the work suggests that we are not on target to meet our NDC, but nevertheless the obligation simply is that we pursue the domestic mitigation measures with the aim of achieving it. So we may still be complying with that. And the final one is then the obligations to account for a country's NDCs and maintain a national greenhouse gas inventory. Now, you'll see in the second of those articles I have there that it talks about that the countries are to provide a national inventory of anthropogenic emissions by sources and removals by sinks of the greenhouse gases. Again, notice the focus on the anthropogenic emissions. And there's an accounting mechanism which can be done to make sure that when we say that this is our target, we've counted it correctly, and when we say whether we're achieving it, we've counted it according to proper methodology. Again, it's very likely that Australia will comply with that. I have in the little note down there a statement that there is no requirement for Australia to achieve the economy-wide emissions production target in the NDC. And you'll see in Article 4.4 that developed countries should continue taking the lead by undertaking economy-wide absolute emission reduction targets. So it's a reasonably weak target obligation. So what's the consequences if we were to fail to comply? And I don't think it is actually at the moment likely, based upon the weakness of the language and what Australia is doing. But if we did fail, theoretically it's possible that another party could take us to the International Court of Justice. Two commentators I've put their thoughts about that likelihood. It's pretty unlikely to succeed, and because of the nature of the obligations and because they're administrative and communicative obligations, it's unlikely that we're going to be shown to be in breach. But there are other consequences which are more reputational. There'd be diminished ability to participate in the work of the meeting of the parties to the Paris Agreement. There'd be damage to our reputation in the international community. And this, as I say, would also apply if we didn't achieve our NDC. There is a compliance mechanism, which is not a punitive mechanism. It doesn't punish people for not complying, but it is more a way of trying to assist parties to comply. So there could be suggestions as to how we might better meet our NDC. So at the international, if we're looking at what might be the implications of the Paris Agreement on Australia's international obligations, there's not a lot there. The next one then is to see how it might be incorporated into domestic law. Now, the Paris Agreement is a treaty under the Vienna Convention on the Law of Treaties, so the law as to how treaties get implemented in a nation-state will apply. Now, in international law, there's really two sort of systems. One's called a monarch system, and then when a country which has such a system ratifies a treaty, it becomes part of the law of the land. That's not Australia. Australia is a dualist system, so that is, you've got the two systems, the international and the national, and before the international to operate in the national, you have to incorporate it some way into your domestic law. And the normal way that is done is by passing a new statute or amending an existing statute, and then it can become part of the domestic law. So really what I'm now sort of looking at is the ways in which this might come into the domestic law. Now, the first is that we may do it by legislation. And one of the points I make here is that it really depends upon the terms of the incorporation statute. So you can have very weak ways in which you say that this treaty is being implemented in Australia. If you do that, then there won't be any sort of domestic obligation as such. So I just give you a contrast in the next few slides between countries which have incorporated climate change or air pollution duties at international law into sort of domestic, and where there has been held not to be a justiciable duty. By that I mean a duty that is justiciable in courts, and another example where it has been held that there is a justiciable duty. So let's go to Canada first. And this is a case, Friends of the Earth, of the Government of Canada. What happened here was there was a minority government at the time, and the opposition had sufficient numbers to pass a statute, the Kyoto Protocol Implementation Act, which, as the name gives away, was designed to implement the Kyoto Protocol. And what it was designed to do was require the relevant federal minister to prepare and table a climate change plan that was compliant with Canada's obligations under the Kyoto Protocol. Friends of the Earth then took action because that was the government, which was led by Stephen Harper at the time, was not implementing that. So the legislation was passed against the government's will, and they said, we're not implementing it, so we will not comply with the duty. So Friends of the Earth took the action to try and compel the government to do what they were meant to do under the statute of prepare and table this climate change plan. The court said, looking at the terms in which the legislation was drafted, that the obligations were policy-laden, it didn't contain any objective legal criteria, and didn't require strict compliance with the terms of the Kyoto Protocol. In those circumstances, the court said it would not and could not order the minister to prepare a compliant plan. So there was an example where, although there was purporting to be an incorporation statute, the terms in which it was drafted didn't achieve the goal of creating a domestic obligation. Let's take another one. This one is in England. It's about sort of one of the number of cases about expansion of airports, Heathrow, etc., and so there's going to be a third runway. There was a Climate Change Act 2008, which is in the UK, and there were certain steps that needed to be followed through that, and there was, on the face of it, some duties that were needed to be done. Again, there was a challenge to the government and said that they hadn't complied with that. They were meant to do more things about assessment in the early stages, about the impact of greenhouse gas emissions, went to the court, and the court held that the errors of law occurred in this preliminary consultation process and not at a later stage. And the language in which the statute had been drafted was such that it didn't create this justiciable duty. And it contrasted if it had been drafted in a different manner. So again, there wasn't a justiciable duty, even though there was this Climate Change Act. So let's go see now an example where it was implemented. Now, this one is a European Union one. As you know, in the European Union, they have a number of directives, and these directives are applicable to those countries that are part of that Europe. And at the time, the UK, it still is at the moment, part of Europe, and so this EU directive was applicable. And this was concerned with the nitrogen dioxides in the air and trying to reduce those nitrogen dioxides. And they had to come up with a plan as to how to do that, and they had to do it by a certain time limit to meet certain levels. And they failed to do so. So the directive specifically said what time period they had to do it by. The government was nowhere close to complying with that, so it was challenged by a group, environmental NGO, which took action to compel the government to do it. And the Supreme Court of England agreed with the challenger and said there was a justiciable duty. And they made one of the, exactly very rare for the UK Supreme Court or House of Lords formally, to do this, but they've actually issued a mandamus compelling the government to prepare the plan in accordance with the EU directive and to achieve the target. Now, there was ongoing litigation about, because the government still was recalcitrant and wasn't complying with the target date, and so there was further challenges about that. And the court again said they have to comply with that date, and now the UK government has to do it by end of April, so next month. So there's an example where the terms of that EU directive, which became a sort of incorporated legislation, were drafted in a way which created this justiciable duty. So the legislation, not just a matter of passing legislation, it's very important that the terms of the legislation are drafted in a way which creates a justiciable duty. Otherwise, there's not going to be a domestic obligation. All right, is there any other way? Well, it can also be incorporated into policy. Now, that won't become, as the name suggests, it won't become law. It's still policy, but policy may influence law. And it can influence in a variety of ways. And so I just give two examples. One is where if there were human rights obligations and rights and obligations, an example might be under constitutions, but it could also be under statutes. And if there were to be climate change has consequences for impacting on those human rights, there may be an opportunity to look at the policy which is incorporating Paris Agreement obligations and NDCs, both for mitigation and also for adaptation, in interpreting the rights and the breaches of those rights and the remedies that could be granted. So I give one case there. It's a Pakistan case. Many of you may have heard about it, but there was a farmer who was being adversely affected by the continued drought, which he said was a consequence of climate change in Pakistan. He said that impacted upon his human rights, particularly sort of, for family and livelihood and, no clean water to have. So he took action for a remedy to say my human rights are being breached, there needs to be something done about it. And particularly what he wanted was for the Pakistan government to take action to implement the policies that the Pakistan government had adopted for adaptation to climate change, because they weren't doing it. And he said their failure to take adaptive action was exacerbating the problem and the impact on his human rights. And the court in Lahore agreed and set about making quite comprehensive orders for setting up a climate change commission and ordering that climate change commission to come up with an action plan to implement the government's policy. So that's just showing a way in which you could see the Paris Agreement being implemented into policy and then that having an influence on court litigation. The other one I just wanted to sort of say is in tort, there as a duty of care. I won't go into all the elements of it, but you've got to have the duty of care and what is its content. You've got to have the breach of the duty, and then you've got to see what might be the remedy. And we could see the famous case in the Netherlands, Ugenda Foundation in the Netherlands, where the court there held that the Dutch government, the Netherlands nation state, was in breach of a hazardous negligence duty, and it ordered the Dutch government to take action to mitigate its emissions by a certain date. But when you read the judgment, what you're seeing is that they're having regard to broader policy questions. They looked at human rights, they looked at what other countries, developed countries, are doing in order to inform their interpretation and application of the Dutch law. So this is another way we can see this influence that you might find from Paris coming into a policy and then influencing the court's interpretation of the law. So let's move now to a bit more amorphous one about does it change societal values, norms and customs? And I'll suggest a few ways in which it might be. The first is that what we see coming from Paris Agreement is that there is now a global norm that countries are to take action to mitigate climate change. That's a big step, right? Before, with the debate about the Kyoto Protocol and leading up to Copenhagen, a lot of countries were saying we shouldn't have to take any action at all, right? And so the fact that you've got so many countries now agreeing and saying action is required, that's an important point. It's changed the norm. And the next thing is that not just taking action, but you do it in a way which you can actually accurately determine and compare the level of commitment of the countries. And you do this through the way in which you prepare your NDCs and the way in which you measure whether you're complying with your NDCs. That in itself has created a norm, that it is legitimate to actually account for your NDCs and how you're achieving them. So that's another step. The next one we can see is that the Paris Agreement is universal. As Justine was saying, that the problem with the Kyoto was it was said that the developed countries have an obligation, but the developing and other countries don't have an obligation. So we had this sort of dichotomy between the developed and developing, between rich and the poor, north and the south. That's been overcome by adopting the bottom-up approach, but that was what enabled the agreement to become universal. That is that, and that's very important, that means every country has an obligation. It may be common but differentiated responsibility, true, but everyone has some obligation, and that's an important point. And within those countries, every entity within the country, both public sector and private sector, have an obligation because it's the sum of the parts that is going to make a country achieve or not achieve its NDC. So this universality is a new norm. The next one I want to deal with is the fact that climate change now will be considered a relevant matter that should be considered in the approval of new developments. It's clearly embedded in the whole Paris Agreement that you have to be mindful of it. You can't, every activity that is likely to increase the sources of greenhouse gas emissions or remove the sinks which capture the greenhouse gas emissions is going to make a difference. And so the concept that climate change and its consequences are not a relevant matter to be considered, I think, has changed. And so that now becomes a relevant matter. So I want to now deal with the question about some fact-finding. So it's certainly, by reason of the Paris Agreement and its terms, will make it easier to establish causation in these respects, at least. The first is that increasing greenhouse gas emissions causes climate change. The second is that climate change is caused by humans through an increase of the sources or a decrease in the removal of sinks. And the final one is that climate change is having and will continue to have dire consequences on the environment and human rights. So just quickly looking at those. The first is reasonably obvious, that if you're going to have greenhouse gas emissions, that leads to climate change. Right? We look at the climate change agreement and say, well, isn't that obvious? The Convention and the Paris Agreement, but of course there have been a lot of denials over the years, and leading up to whether countries should, developed countries should sign on to the Kyoto Protocol, whether they should go to any new replacement to Kyoto Protocol, which was discussed in Copenhagen. There still was this debate, was it really greenhouse gas emissions which is causing climate change? That's been resolved. The next one is that the question of, are humans responsible Is it sunspots? Is it other things? That volcanoes? There was a serious discussion about all of these, that it wasn't really humans. That again now is really resolved. If you look at the number of the places in the Climate Change Convention, it talks about anthropogenic, emissions, and that's what needs to be addressed. In the accounting in the NDCs, it's about the anthropogenic emissions through the sources and removal of the sinks. So I won't go through, but there's a number of points there which you could have a look at the particular provisions. And the next one is that this climate change is having consequences on the environment. And again, we see that in a number of places. I mean, the Article 2.1 does it, the very existence of the Paris Agreement shows it, Article 7 is one, and if you looked at Article 7.2, you see it talking about adaptation, but it talks about that the parties recognise that adaptation is a global challenge that is faced by all, with local, subnational, national, regional, international dimensions, and that is a key component and makes a contribution to the long-term global response for climate change to protect people, livelihood and ecosystems. So, and Article 8.1 would be another one. So clearly there's a recognition that climate change has consequences. All right. However, we do need to say a caveat, and that is that the science has not advanced, and Paris Agreement, dealing with the factual connections, one area that we think I would suggest that there is increased certainty would be that the emissions of an individual country have this consequence on global climate change, and this in turn has a detrimental effect. And so the agenda case is one where that was found. A second way where there's this causal connections is a failure to take regulatory action and the connection with global climate change and future localised environmental harm. In the case of Massachusetts and the EPA in the United States would be an example where it was held that the failure of the EPA to make a regulation or a rule regulating emissions from motor vehicles was causally connected to climate change and the consequences for the petitioners. And the next one is that for those developments, and particularly mines, that have this concept of Scope 3 emissions, it's been held that should be taken into account, that there's a causal connection between the sort of mining of coal and its subsequent burning and then causing climate change and having consequences. So some cases was the one of Grey there. What's my first one there? Grey in New South Wales. I've given one in Victoria about the Hazelwood station, and then there's this series of litigation in Queensland where the relevancy of Scope 3 emissions has been upheld. But the caveat that I wanted to started to say a bit prematurely is that we're still a long way from finding that a particular extreme weather event, for example, a particular cyclone or a particular flood or a particular bushfire, was caused by the emissions of a particular country or a particular source, a particular power station or coal mine, or that connection is still not there, but the broader causal links that I've said earlier are. Now, I did want to, but I'm running out of time, but can I just show you on the slides this concept of the impact of the Paris Agreement on directors' liabilities. And a recent speech by Jeff Summerhayes, who's one of the executive board members of the Australian Prudential Regulation Authority, and has acquired some publicity in the last month or so, it talked about the fact that the Paris Agreement is fundamental. It's a bit of a game changer and will influence corporate behaviour and the responsibilities of directors. And in the bottom of the quote there, you can see some of the things that it causes. So the exposure of insurance firms to losses from increasingly frequent and severe natural disasters, the exposure of the balance sheets of banks and insurers to real estate impacted by climate change, the repricing, even the stranding of carbon-intensive assets in their loan books, and the exposure of owners and managers, and particularly we're talking about, for example, in superannuation sector, which has carbon-intensive equities. There's been also some publicity about a legal opinion about the liabilities of company directors, and that they have an obligation under their statutory duty of care and diligence to consider the climate change risks that intersect with the interests of the company. And this is particularly necessary for directors in the insurance sector and, of course, in the energy sector. Other areas where there might be an impact, one is in relation to disclosure. So disclosure to banks and to shareholders and the stock exchange. I give an example there of the Australian Stock Exchange guidance note, which recommends that there be disclosure in relation to exposure to, amongst other things, environmental risks, which would include climate change, and how that they intend to manage those risks. Another one is how does climate change impact on the valuation of assets? There's been investigation in the United States by the US Securities and Exchange Commission of ExxonMobil and its valuation of assets. It says that it's bringing it in on the books at too high a level, that those should be valued at a lower level because of the climate change risks. There's also been about information. If they peddle information to say climate change is not real, it's not happening, that misinformation may expose the directors and the corporation, and there's been an investigation again against ExxonMobil in the United States. Another aspect to consider is the risk of litigation. There is a risk that a company may be sued, for example, for negligence, for failing to foresee, to mitigate or adapt to the effect of climate change on the company's business and on its assets. There's a risk that approvals might be declined or significantly delayed on environmental grounds, including climate change and its consequences. And therefore, those risks and costs will increase. And there is this risk that future investments may be exposed to climate change and decline in value or become stranded assets. And we'll jump through there. So the last one is the ripple effect. And it's not quite the domino effect that everyone was concerned about in Vietnam, but there is the likelihood that Paris Agreement will influence other countries and litigation in those countries. Once that litigation happens, then people in Australia look to that litigation and say, could that happen here? And that may provide the inspiration. So you do see this effect of Paris having an influence on other countries, which then may have an influence on Australia. So with that, just the concluding remarks is that the Paris Agreement is evidence of increased political ambition to mitigate and adapt to climate change, and is also increased certainty, scientific certainty, that anthropogenic climate change will have dire consequences for the environment and human rights. Undoubtedly, judicial decision-making will progress to reflect these new political norms and this increased scientific certainty. The Paris Agreement is only the first step. There will be successive climate change negotiations under the framework of the Convention as well as the agreement, and they have the potential to give rise to new obligations. So hopefully that gives you some insight into the crystal ball that is the Paris Agreement and its impact on environmental jurisprudence. Thank you.